My name is Jay Chauhan, and this video today is on the topic of the family law and some of the issues that the parties involved in a breakdown of marriage may have to deal with. So we have Roshni Vora here. She's an articling student today, but next year she'll be called to the bar. So she'll frame the questions, and I will attempt to answer those questions. And let's see what questions you have, Roshni.
All right, well, to start, since we're talking about family law, within family disputes, what should the client expect in the first meeting with the lawyer?
The first meeting is very important to find out what solution the lawyer is presenting, and to give you some more detail of the kinds of issues that he might raise. It includes, for example, is he suggesting a separation agreement? Is he suggesting a divorce, mediation, or any other remedy that he might propose? But these are the major issues that he might deal with. But more important than the issues is the question of the lawyer's attitude and the position on how he's going to solve the problem. Is he going to suggest litigation and a confrontation with the opposing party, or does he believe in mediation? And in the family law, too many people have had very bad experiences in which the adversarial system does not work properly when it comes to the family issues. So the lawyer's attitude and the position is very important to find out in the first meeting. So these are the issues to be addressed or understood in the first meeting of the client with the lawyer.
All right, there's this concept that a lot of people have heard of, but I'm not sure they know too much about. If you are getting married, should you be getting a prenuptial contract?
In my view, I think in the modern society it's a desirable thing. You see, only a few years ago, the marriage contract or prenuptial agreement, as it is called, or in the technical terms in the Family Law Act of Ontario, called the cohabitation agreement, was not even recognized in the law. But now it is recognized, and in view of the number of divorces, in my opinion, the prenuptial agreement is a very helpful thing to have, because if you don't have it, and suppose a separation happens and the risk element is high these days, then the cost of going to court and dealing with the legal system is totally out of proportion, excessive, and therefore I would say that it is somewhat desirable. It's also desirable if the two parties who are getting married have different types of points of value, differences in the background, financial background of the parties, and therefore these issues should be addressed right up front so that it is helpful if something does go wrong. And I think the idea is very falsely understood sometimes, that if you are in love and you're getting married, how can you talk about the marriage contract? But in the modern society, my view is, based on my experience, that it is helpful. It is not a questioning of the relationship, but rather the understanding that you want to achieve and what kind of a marriage the two parties want.
All right. With regards to separation, what are the common issues to be dealt with in such a situation?
The issues that you deal with include property, support, the matrimonial home, and the custody of the children. These are the major issues that you have to deal with. If you prepare a separation agreement, you have to talk about each issue. And in my view, it is very desirable that these issues are sorted out by agreement rather than being taken to court for resolution. If you commence a petition for divorce and have not resolved these issues, that each issue will be negotiated by each person through the lawyer to the opposing lawyer, who then talks to his or her client, and then you're trying to find resolution to see if there's agreement or disagreement on the issues of custody, support, etc. And if you cannot find the resolution, when the petition has been commenced, they happen within the framework of litigation, which becomes extremely expensive. So what I recommend is that you work out with understanding the issues in a separation agreement then ask for the petition for divorce after the agreement is signed. If it is not possible to sign, of course, then you have to go to court to have those issues sorted out.
All right, amongst the issues you just mentioned involving separation, can you expand upon this concept of net family property?
Well, when the Family Law Act came into being about, 25 years ago, so today is 2014, but roughly around that time, the whole concept of the property in the marriage changed in Ontario. Prior to that one was a totally different law, and currently, and since the Family Law Act was enacted, the essential concept is the concept of putting the family property into, so to speak, one pot. When parties marry, they commence with assets which they had, which are their own property, but the property they accumulate during the marriage becomes the family property. And when they separate or divorce, you calculate the amount or the property that was at the commencement of the marriage, in the sense not what they had brought into the marriage, but what you began to earn and accumulate at the commencement, and what you had at the end is to be divided equally. That's the concept of the net family property, of which the matrimonial home is the primary asset, and you may have other business assets, you may have other properties which are all to be divided equally regardless of the ownership of the property. In other words, you can't just say that this property is in the name of the husband or the wife and say that that person owns the property. Now, this is subject to what we earlier talked about as the prenuptial agreement. If you have an agreement, the agreement supersedes the arrangement of net family property. If you do not have an agreement, then the court will sort out the questions of the net family property, and then you equalize the net amount to each person at the end of the marriage. That's the concept.
All right, now I know this is one question that probably comes across everyone's mind. Why does it cost so much to get divorced?
Well, for one reason, that the system for getting divorced and dealing with the issues in a confrontational manner in the adversarial system creates the argument of basically what are you supposed to get at the end of the marriage. For example, the question of custody. Who is the best parent to look after the child? What is the person's net worth, and how much of it should be the net family property and how it's to be divided. Where you do not reach an agreement and you take it to court, a typical lawyer is charging in the vicinity of $300-400 an hour, and you have to go through all the procedures virtually by the hour in the court and outside the court, and then you find a resolution of the problem. Now, one of the problems from my observation is the approach and attitude of the lawyer himself. The lawyer has an attitude of reconciliation, and more importantly, the client. If the client begins to see the legal conflict as a continuation of the conflict in the marriage, then it can become very expensive. So it's not just the lawyer, it's the attitude of the lawyer along with the attitude of the separating parties, which put together create the lengthy time and the cost of the divorce. Some jurisdictions, and Ontario also is moving in the direction of trying to find resolution from the mediation types of arrangements, which in my view are more appropriate in a family separation situation. But if not, then the cost of litigation is very high. So is that the questions?
Yes, that is all, but thank you.
Thank you, Roshni, and so I thank the audience as well. And you might want to watch other videos that I have on the channel Jay Chauhan, and we will be covering a number of topics aimed at the public wanting to use the legal system, and also for other members of the legal profession also in terms of our views, my views in particular, as to how this issue should be addressed in the process of litigation in the court system. Thank you.